You are 4 sentences into an email that starts with "to whom it may still concern," and your cursor is sitting on top of a button that's about to reach 1,140 people in the next 6 seconds. Somewhere on Earth, right now, a version of this exact scene is happening in an office park in Ohio, in a Slack channel standing in for an office that no longer physically exists, in a call center in Manila running the graveyard shift so it lines up with a client's morning in Chicago. The furniture changes, the scene doesn't. You've CC'd the CEO, you've CC'd HR, you've CC'd the guy in accounting you've spoken to exactly twice, both times about a broken printer, because at this point you just want witnesses. Somewhere around paragraph 2, you've typed the phrase "for the record," a phrase that in the entire history of human communication has never once preceded anything good. Your thumb finds the button. Your heart does that thing hearts do sometimes right before something big, that little stutter, like it knows something you haven't caught up to yet. You click send. Yep, that's me. Well, it was me for about 4 more minutes. Oh, hey there. Sorry, I get ahead of myself. I've had some time to work on this story, and some time is doing an enormous amount of lifting in that sentence, because I've been dead since roughly 90 seconds after I hit that button, and time works differently once you stop needing it for anything. Here's the short version. I spent 11 years being the reliable one at that company, the one who covered the bad shifts, the one who sat in meetings and never said the thing everyone in the room was actually thinking. And on my last Tuesday on Earth, I decided today of all days, was the day the reliable one would finally say it. All of it, to everyone, at once, in 14-point font, with receipts. I hit send. For about 90 seconds, I felt genuinely like the main character of something. Then an artery that had been quietly plotting against me for about 6 years, the one my cardiologist had mentioned at my last physical, gently, in the specific tone doctors use when they've already guessed you're not going to do anything about it, finished what it started. I never saw a single reply, never found out if HR called an emergency meeting, never found out if it worked. Which might be the only mercy in this entire story, because since that day I've done nothing but watch other people run some version of my exact play, thousands of them. I don't sleep anymore, that's a genuinely different video, so I watch, endlessly, with no ability whatsoever to reach through the screen and grab anyone's wrist, which makes me, functionally, the most obsessively well-informed person who has ever lived on one extremely specific subject nobody appointed me to study. What actually legally happens after you tell an entire company exactly what you think of it on your way out the door. So let's build the whole thing properly. The mechanism, the timeline, the myths people believe right up until the moment they very expensively don't, and the parts of this that could genuinely protect you if your thumb is ever hovering over that button too. Which brings us to something stranger than the email itself, what your brain was actually doing in the 4 seconds before you hit send. Here's the part nobody covers in orientation. The decision to blast a scorched earth message to the entire company doesn't get made in the slow, careful, weigh the consequences part of your brain. It gets made somewhere closer to the part that used to decide whether the rustling in the grass was a snake. Months of what your nervous system correctly logs as social threat, a manager who takes credit, a promise that quietly evaporated, a paycheck that didn't show up, keep a structure called the amygdala running hot, and the amygdala isn't a details person. It doesn't distinguish especially well between "a predator is stalking me" and "my manager stole my idea in front of the whole team again." It just registers threat, threat, threat. Then at the exact moment you finally confront it, your brain adds a jolt of dopamine, not the pleasure kind, the anticipation kind, the same chemical signature that lights up right before a big reveal. Your brain isn't rewarding you for the email itself, it's rewarding you for finally doing something about the threat it's been tracking for months. That part is known. Decades of stress research back the basic mechanism, even if nobody's published a paper titled "The Reply All Cortex."
What's likely, going by that same research, is that this is also why the email tends to get sent at the worst possible hour, 11 p.m., right after the meeting, right after the fourth coffee of the day, because your prefrontal cortex, the part of you responsible for running a cost-benefit analysis before you do something irreversible, is one of the very first systems to go quiet under stress and exhaustion. You didn't skip thinking about the consequences. The part of you that was supposed to do that thinking had already clocked out for the night. Evolution never built you a "will this hold up in an employment tribunal" module. It built you a "get the threat out of the cave" module, and every single day that module gets handed a legal risk assessment it was never designed to run, and every single day it runs it anyway, with tremendous misplaced confidence. Fast fact, the brain network most active while you're drafting the "let me be honest for once" email overlaps heavily with the network that lights up in a gambler one card away from a big win. It's the anticipation doing the work, not the outcome, which is a genuinely miserable thing to learn about yourself approximately one email too late.
Here's the part your career never happens. Let's run it minute by minute. Minute 0, you hit send. For roughly 90 seconds, you feel something close to euphoric. That feeling is real, it's chemical, and I need you to know upfront that it is not going to last nearly as long as the consequences will. Minute 6, someone forwards it outside the company. This happens faster than you'd ever guess, and it happens almost every time. Hour 1, the mail server's logs now contain a time-stamped, essentially unforgeable copy of exactly what you wrote and exactly who received it. Hold on to that detail, it matters more than almost anything else in this whole video, and we're coming back to it by part 4. Hour 3. HR opens a file. Not because anyone involved is a villain, a message naming specific people and specific accusations is procedurally close to indistinguishable from a formal complaint, and formal complaints come with documentation requirements no matter how dramatically they arrive. Day 1. Legal reads it. If you made factual claims about a specific person, not feelings, not vibes, actual claims, she falsified the timesheet, he was skimming the department budget, legal is now quietly running 2 separate questions. Is it true? And can you prove it's true? Those are not the same question, and the gap between them is where a lot of people get hurt. Week 1. If you had anything unsigned on the table, a severance offer, an exit package, it can quietly get revised. Nobody is legally obligated to sweeten a deal for someone who just publicly set the building on fire, and most companies won't. Month 1. Your old employer gets the first reference check call. What gets said next depends entirely on jurisdiction, internal policy, and how litigious everyone's feeling that week. An unsatisfying answer and also the accurate one. Month 2. The email is still online somewhere. Not because anyone's being cruel about it, because nothing you send to 1,100 people ever fully leaves again. And that's only half the story, because here's where the law gets almost insulting in how little ceremony it actually requires. Across most of the United States, the employment relationship runs on something called at-will employment, a doctrine holding that either side can end things for almost any reason or no reason at all without warning. No federal law requires your employer to fire you in person, in writing, or with any dignity whatsoever. Text message, email, a sticky note on your monitor. All perfectly legal, all somewhat soul-crushing. Why would a legal system build something this blunt on purpose? Follow the logic back. At-will doctrine hardened into American common law in the late 1800s, largely as courts reached for a simple symmetrical default. If the employer doesn't owe you a reason to stay, you don't owe them one to leave either. It was never built to be humane, it was built to be even-handed, and those turn out to be very different design goals. Here's the trade-off nobody puts on the offer letter. The same bluntness that lets a company fire you over Slack is the same that lets you quit
quit by email with zero notice and zero legal exposure just for the act of quitting. Abruptly resigning on its own isn't a violation of anything. You are allowed to be dramatic. The drama itself was never the risky part. And the doctrine hasn't stood still. In 1959, a California court heard the case of a man named Petterman, fired by his employer after he refused to lie on oath on the company's behalf. The court ruled that firing someone specifically for refusing to break the law couldn't stand, even under at-will employment, the first real crack in the doctrine, now known as the public policy exception. Since then, the overwhelming majority of U.S. states have adopted some version of it. You can still be fired for almost anything, but not, generally, for refusing to commit a crime, reporting a legal violation, or serving on a jury. Montana went even further and, since 1987, has done away with pure at-will employment by statute entirely for employees past probation, which makes it the one state in the country where "I can fire you for no reason at all" simply isn't true anymore. The risky part for the rest of us was never quitting. It's everything you say on your way out the door, and that's a completely different legal category with a completely different rule book that most people accidentally lump in with just quitting. Here's the part nobody tells you, and it's one of the most common fears I watch people carry into this exact moment, usually for no good reason. Myth 1. Myth: using your own company email account to message everyone at once could get you criminally charged with computer hacking. Reality: as of a 2021 U.S. Supreme Court ruling, almost certainly not. Not under the law most people are actually picturing when they get scared. Why it's false. There's a federal statute called the Computer Fraud and Access Act, written in 1986, decades before anyone anticipated a furious employee with company-wide send permissions. For years, courts fought over what it meant to exceed authorized access to a computer system. Did that phrase cover using a system you're technically allowed to touch for a purpose your employer would hate? In 2021, in Van Buren versus United States, the Supreme Court settled it, 6 votes to 3. Their answer amounted to what one law firm nicely called a gates up or down test. Either you can access a system or you can't. If the gate's up, if you have a working login and a functioning send button, using it for a reason your employer despises doesn't quietly flip the gate back down. The court was explicit that reading the statute any other way would turn a staggering amount of completely normal workplace behavior into a federal crime, including, this is nearly a direct line from the opinion, an employee using a work computer to send a personal email. That doesn't mean you walk away clean. Your employer can still come at you through completely different doors: a breach of contract claim if you violated a signed policy, a civil suit over confidential information, sometimes a defamation claim over the content itself. But the federal government is going to treat my inbox like a hacking case. That particular fear for the average office worker is known to be wildly overstated since 2021. It's the wrong monster to lose sleep over. There's a more realistic one coming up shortly. Speaking of terrible ideas dressed up as good ones, this is the move I've watched more people botch than almost any other: the confidential documents in the farewell email move. You've found something, a spreadsheet, an internal memo, actual proof that the company did something it shouldn't have, overbilled a client, faked a compliance number, buried a safety report. You attach it to the email. You tell yourself, quite reasonably, "I'm not the villain here, I'm the whistleblower." Myth 2. Myth: attaching proof of wrongdoing to your company-wide goodbye email makes you a legally protected whistleblower. Reality: depending on exactly what you attached and who received it, it might make you a legally exposed one instead. Why it's false? There is real federal protection for disclosing a company's confidential trade secrets in order to report a legal violation, written directly into the Defend Trade Secrets Act of 2016, in a section 18 U.S.C. Section 1833B that Congress built specifically to shield whistleblowers. But look closely at the mechanism, because the mechanism is the entire ballgame. The immunity only covers disclosure made in confidence to a government official or to an attorney for the purpose of reporting a suspected violation of law.
An email to 1,100 coworkers is structurally the exact opposite of confidential disclosure to an official. It's a broadcast. The statute was never written to cover broadcasts. This is one of the more quietly brutal gaps in how people understand their own protections. The version of you that emails a regulator or an employment lawyer in confidence describing exactly what you found, that version of you may be standing on genuinely solid legal ground. The version of you that CCs the entire company distribution list with the same attachment has taken a protected act and performed it in the one format the law doesn't protect. If what you found is real and it matters, the unglamorous move is the protected one. Document it. Take it to an employment attorney or the relevant regulator quietly. I know it doesn't have the same energy as the company-wide email. It also doesn't come with the legal bill. Here's the part that surprises almost everyone I watch go through this, because up to now it's all sounded like a one-way street. It isn't. Defamation in almost every U.S. jurisdiction needs the same basic ingredients: a false statement presented as fact, not opinion, communicated to at least one other person without legal privilege covering it, that causes real harm to someone's reputation. Miss any one of those ingredients and there's no claim, however nasty the statement sounds out loud. That statement of fact requirement does a lot of quiet work. Pure opinion is broadly protected. I think management here is a disaster is safe almost anywhere, but dressing a factual accusation up in opinion language doesn't automatically launder it. In my opinion, she's been stealing from the company. Reads like an opinion and functions legally like an accusation of theft, because a reasonable listener would take it as a claim about something that either did or didn't actually happen. Courts generally look past the sentence structure to what's actually being asserted. And you don't have to name someone outright for it to count as being about them. If it's reasonably clear from context, the department, the title, you know who you are, the law can treat it as identifying them just fine. Vagueness is not the shield people assume it is. Here's the genuinely good news, and it's a big one. Truth is close to an absolute defense. If what you said is factually accurate and you can back it up, you are generally in very strong shape, regardless of how devastating the statement is to someone's reputation. The law isn't trying to protect people from true things said about them. It's trying to protect people from false things. But here's the twist almost nobody sees coming, the part where the company can end up on the wrong end of this too. Some states, California is the seminal one going back to a 1980 case called McKinney versus County of Santa Clara, recognize something called compelled self-publication. If your employer gives you a false, damaging reason for your termination, and it's reasonably foreseeable that you'll have to repeat that reason to a future employer during an interview, the original employer can be held liable for defamation, even though they technically never told a single outside person themselves. Your repeating it under compulsion counts as if they'd said it publicly. It's not universal. Texas has the highest court explicitly rejected the doctrine, and plenty of states haven't ruled on it either way. But where it applies, it flips a piece of this story most people never think to examine. And that's only half the paperwork story, because most people walking into this moment are also carrying documents they signed years ago and never read twice. Take non-disparagement clauses. The line buried in a lot of offer letters and nearly all severance agreements promising you won't say anything negative about the company after you leave. For a long time, employers treated these as close to bulletproof. Then, on February 21, 2023, the National Labor Board ruled in a case known as McLaren-McComb that broad, undefined, indefinite non-disparagement and confidentiality clauses in severance agreements can themselves be unlawful, not just unenforceable, unlawful, because they can chill a worker's protected right under the National Labor Act to discuss working conditions with coworkers. Picture a warranty written so broadly and so vaguely that the vagueness itself becomes the legal problem. That's roughly the board's logic.
I want to be precise here, because overstating this is exactly the kind of claim that ages badly. This doesn't erase every non-disparagement clause everywhere. It applies most clearly to non-supervisory employees covered by the NLRA. Enforcement can shift as the board's own membership changes over time, and plenty of narrower, carefully worded clauses still hold up fine.
File My Non-Disparagement Clause is definitely fake now under myth, not reality. The accurate version is quieter. Many broad non-disparagement clauses are on shakier ground than they used to be, and a lawyer can generally tell you which category yours falls into in about 10 minutes. Separately, in 2022, Congress passed something called the Speak Out Act, which does something narrower but close to ironclad. It voids pre-dispute non-disparagement and non-disclosure clauses specifically when it comes to sexual harassment or sexual assault claims. If that's what you're sitting on, a clause signed years before any of it happened generally can't be used to silence you now. That one's about as close to a clean, settled rule as employment law gets. And here's a number that catches almost everyone off guard. In every U.S. state, voluntarily quitting a job, including quitting dramatically on principle, effective immediately, disqualifies you from unemployment benefits unless your specific reason meets your state's definition of good cause. Unsafe conditions, certain kinds of harassment, unpaid wages can qualify. My manager was insufferable and I finally said so, almost never does, however satisfying it feels in the moment. Think of it as a toll booth nobody mentions until you're already through it. The bridge you just torched was also, it turns out, the one leading to a few months of income while you look for the next job. If you've ever drafted one of these emails and talked yourself out of it at the last second, good, genuinely. Drop a comment with how far you got before you closed the laptop. I read everything. I have, as previously established, nothing but time. And the rule breaks somewhere, because it always does. If you work for the government, the calculus shifts. Public employees in a lot of circumstances carry First Amendment protections that private sector employees simply don't have. Speaking out on a genuine matter of public concern can be legally protected in ways a private company's inbox will never be. If you're in a unionized workplace, the National Labor Relations Act's concerted activity protections can shield group communication about wages, hours, and working conditions even when it's blunt and even when it names people, as long as it's genuinely about those things and genuinely done with or on behalf of coworkers, not just one person venting alone. And in California, state law goes further than almost anywhere else, refusing to let a non-disparagement clause be used to silence you about discrimination, harassment, or other unlawful conduct, no matter how airtight the company's lawyers thought the paperwork was. None of that means anything goes. It means the legal weather changes by state, by sector, and by exactly what you're saying, which might be the least satisfying sentence in this entire video, and also the most honest one. Here's the trade-off nobody puts in the onboarding packet. Catharsis and protection pull in opposite directions, and you cannot maximize both at once. The version of the email that feels best to send, specific, furious, addressed to everyone, holding nothing back, is very often the exact version that creates the most legal exposure. And the version that's legally cleanest, measured, factual, sent to as few people as necessary, rarely feels like enough. That's not a flaw in the system. It's the system doing roughly what it's designed to do. The law generally protects your right to say true things calmly to the people who need to hear them, and generally does not protect your right to say anything, however phrased, to everyone, forever, with your full name attached. Your amygdala wants the company-wide version. Your future self, 6 months out, filling in a job application that asks for references, wants the other one. I'm not telling you which to choose, I'm telling you that pretending it isn't a trade-off is how I ended up watching my own old inbox from somewhere outside my body, instead of enjoying whatever it is dead people are supposed to be enjoying. If you've made it this far, either you're genuinely curious, or, more likely, there's a draft sitting in your outbox right now and you're hunting for permission. I can't give you permission, I can give you a checklist. Find your actual employment agreement and any severance paperwork before you write a single word. Know what you signed, specifically, not what you remember signing.
Separate fact from feeling sentence by sentence. I felt disrespected is safe, essentially always. She falsified the numbers is a factual claim you'd need to be able to prove if it were ever challenged. If you genuinely have evidence of real wrongdoing, take it to an employment attorney or the appropriate regulator in confidence, not to the whole company distribution list. That's the version the law is actually built to protect. Assume permanence, assume forwarding, assume screenshots. Write every sentence as though it's read aloud someday in a room you're not in. Check your state's unemployment good cause rules before you quit on principle, if the paycheck gap matters to you at all. It's a 5-minute search that can change the math substantially. Keep your receipts, documentation, dates, saved emails without attaching them to the goodbye message itself. Evidence and theater are different tools. Don't merge them. If a clause in your severance agreement seems built to gag you about something genuinely unlawful, don't assume it's automatically toothless, and don't assume it's automatically enforceable. A short conversation with an employment attorney will tell you which. Give it 24 hours, not because your anger isn't valid, it almost certainly is, but because the part of your brain equipped to catch a legal problem is, by hour 24, usually back on shift.
If you still want the send, still want the mic drop, still want the company to feel exactly what you felt, run the final draft past a lawyer first. A short consult costs a fraction of what a defamation claim does. And if none of that appeals to you and you'd rather just leave quietly and never look back, that's allowed too. Nobody in this story is a coward for choosing the boring exit. I promise you, on the word of someone who tried the other one, the boring exit has an excellent survival rate. Let's shift gears for a second, because I don't want you leaving this video more afraid of your own inbox than you were before you clicked on it. Every piece of this, the NDAs, the non-disparagement clauses, the whistleblower statutes, the whole tangled architecture exists because two things are true simultaneously, and the law is perpetually imperfectly trying to hold both at once. Companies have a legitimate interest in protecting confidential information and their reputation, and employees have a real protected interest in being able to say true things about unsafe, unfair, or unlawful conditions without losing everything for saying them. The system isn't purely rigged against you. It's just messier and far more specific than either you can say whatever you want or you can never say anything. It's closer to a hallway of doors, some open, some locked, and most people never check which is which before they start pounding on the nearest one. Knowing the actual shape of it isn't the deflating information it might feel like right now. It's leverage. The version of you who knows confidential disclosure to an attorney is protected and a company-wide blast isn't can get a genuine concern taken seriously by someone with the actual power to act on it, instead of watching it get deleted from a server and filed under HR incident. The version of you who knows your state's unemployment good cause rule can time an exit instead of torching one by accident. None of this is about making you smaller or quieter or more afraid of your own job. It's about making sure that if you're ever going to burn something down, you're doing it on purpose, with your eyes open, instead of getting outmaneuvered by your own amygdala at 11 p.m. on a random Tuesday. If you've watched this far, and statistically, a few of you have already paused to reread paragraph 2 of an email you haven't sent yet, I see you. I was you. Here's what I'd tell the version of me who was still alive enough to listen. I wish I'd known the email wasn't actually my last act of agency. It felt like the final word. It was really just the opening move in a much longer, much slower process I never got to see the end of. Lawyers, HR files, a reference check whose outcome I'll genuinely never know, because my own body pulled the plug before the story did. I spent 11 years being careful for everyone else's comfort and about 30 seconds being reckless for my own, and I never even found out if it mattered. I wish I'd understood that quitting and speaking your mind were never actually the same risk. You can do the first one instantly, cleanly, with essentially zero legal exposure, any day you want. The second one just needed about 24 more hours and a considerably smaller distribution list, and it could have been just as true and about 1,000 times safer.
And I wish, honestly, I'd gone to the doctor sooner about the thing the doctor mentioned, but I'm not supposed to end on a safety announcement, so I won't. I'll just say, you, watching this, still have a body that can go to the doctor and a job you can leave through an actual door instead of a diagnosis. Use both of those while